for long because apparently what they're doing, there's like a lot.
Judge, I have one on page 5. Mrs. Morgan, Angela Morgan. And Mr. Cortez is on page 7, but there's a note from Mr. Cortez. There's no paperwork.
More.
So,
I have Morgan at North Broward, Your Honor. Come on, Angela. Stand on the X.
Thank you.
Oh, here we go. All right. Miss Morgan, good afternoon.
Yes, sir. Good afternoon.
You've been charged with 5 counts. The first is a false ID given to a law enforcement officer. And the next 5 counts are warrants. 2 and 3 are cases on misdemeanor, and 1 felony, and then there's a warrant for a violation of probation. Based on the warrant.
Violation of probation.
Pardon?
Violation of probation?
Pretrial, rather. You're on pretrial.
Okay.
Based on the probable cause affidavit, I find probable cause, and bond is set at $100 on count 1, $250 on count 2. 3 and 4 are no bond holds. 5, say 0 bond. I don't know what that is, but I'll leave it at a 0.
I'm sorry, count 5 was already no info,
Okay.
so it's already been.
Okay, that makes sense. So that's a 0 bond. So your total bond, well, you've got no bond hold on counts 3 and 4, and then $350 on 1 and 2.
That's status on the 13 or count 2, and status on 12 or
George Odom on behalf of Mr. McLaunch. First, I would seek appointment on 1501025 MO10A. Second, Judge, I would ask the court to transfer that case, the municipal ordinance case. I have no PC argument on it. To transfer that one to drug court, Judge Zeller.
Do both those things. Just sign an order appointing the firm, and transfer to drug court.
Thank you, Your Honor.
May we call a case out of order?
Sure.
I have an attorney with the Public Defender's Office. He's here on the case on the second look docket.
What do you have? You're done.
I'll take you back.
Good afternoon, Your Honor.
How you
Jason Tom with the Public Defender's Office.
I'm sorry, what case do you have?
Last name is Ekmiro, first name is Richard.
Confi, Your Honor.
All right. Good afternoon, Mr. Ekmiro.
Good evening.
Okay, Counselor.
Your Honor, I saw this was up for a status conference as a second look. Since Mr. Ekmiro was come through magistrate, he has resolved his other case he was being held no bond on. I have spoken with his father. His father is able to bond him out if we can get the bond lowered a little bit. He is able to live with his father if he can be released. I don't know if Your Honor would be willing to release him on some sort of ankle monitor or something like that. Like I said, he does have a residence that he would go to. If Your Honor would be willing to do that.
Let me find out. I don't have a probable cause affidavit here, so State, do you have a position on this?
Your Honor, I'm reviewing it right now. The concern is, Your Honor. Yeah. Your Honor, are you able to? Okay. Your Honor, reading the allegations here and taking.
Yeah. Oh, okay, great. Thank you.
Whenever the court's ready.
Okay. Good.
Your Honor, I'm going to be asking that the bonds be kept in place at this time for several reasons. One, the allegations in this case, the level of violence in the battery, the allegations that he was in possession of a loaded firearm when police initially arrived. Additionally, the case that he resolved that he was out on when he was arrested on this matter and originally had his bond revoked on was a theft and resisting a recovery of property. In that case, the allegation was when a loss prevention officer at a Walmart tried to stop him from getting away from the store while stealing property. He threw his forearm into the face of the loss prevention officer, causing a laceration on the inside of the loss prevention officer's lip. He grabbed onto the loss prevention officer's hair, ripped out a dreadlock from his head. Your Honor, I think a more in-depth.
I'm sorry, I don't mean to interrupt, but currently his bond is, it looks like it's $5,500.
It was raised to $5,500.
$5,500.
Yes.
Count two. Yeah,
Honor,
counsel,
if I may.
respectfully, when a firearm is involved, I think he probably got a gift from Judge Davis because I probably would have given him a higher bond. So the answer is no as far as lowering the bond.
Thank you, Your Honor.
No, that one was.
Ekmira. Let's see it.
Sergio Gonzalez.
What?
Good afternoon, Judge. Mr. Gonzalez here, President of Maine.
How you doing, Mr. Gonzalez?
How you doing, sir?
You're charged with one count of domestic violence battery. Do you find
Yes, sir.
A 2009 aggravated assault against a law enforcement officer.
Judge, if the defense could be heard.
Yes.
Judge, I'm speaking with Mr. Gonzalez. He's been residing in South Florida his whole life. He's 38 years old. He is currently employed. He works at Attorney Services. He's a runner. He's been working for that company for the past 18 years. He makes $15 an hour. Financially, Judge, his only property is he owns a Honda Accord 2006 with approximately 80,000 miles. Judge, he has a 5-year-old son. He's hoping that his family, his cousin particularly, will help post his bond. We'd be asking you to set a reasonable bond. We'd be asking you to set a $1,000 bond and reviewing the probable cause affidavit. It's de minimis contact. I believe he held the wrist of the alleged victim. Your Honor, considering his strong ties to the community, we'd be asking you for a $1,000 bond.
I note in the probable cause affidavit that it appears that the victim was uncooperative in providing a sworn statement. It does look like it was the grabbing of a wrist and not necessarily a punch or a striking in any way. And given the fact that it does not appear that there's a history, at least of reported domestic violence, I will set a bond in the amount of $1,000.
Thank you, Judge. Appreciate it.
Nope.
Wait.
I'm gonna order
Hector.
no contact with the victim until.
Sir, he's ordering no contact. You cannot have any contact with the alleged victim, okay?
Okay, no problem.
Judge, my understanding is that I believe they share a child in common, a 5-year-old. For purposes of arranging child custody, can they do so through a third party?
Yes.
Thank you.
Thank you.
Do you have any of your belongings at the residence or anything?
She moved out of my house.
Okay.
I live there in my house.
Okay,
only.
you can't have any contact. If she's there, you
No,
can't go back.
I know. She's not
all
there.
right,
She's
all right.
at her cousin's house.
All right, go. Thank you, Judge.
Thank you, sir.
Okay. All right, Kevin Lanier.
Mr. Lanier, come on up, please.
Mr. Lanier, you're being held for an Auna County possession of, looks like out of state. It's an out of state hold. Possession of tools, I guess. The other state has set a bond in the amount of $250,000. I do find probable cause based on the out of state hold. Good luck to you, sir. Looks like they're willing to. Deborah Lugo.
250, just like I told you. Judge, I've been advised Deborah Lugo bonded.
Emily Polino.
North
That'll
Broward.
be a medical reset, Your Honor.
Okay, we'll reset that for tomorrow morning.
Tomorrow morning or tomorrow afternoon?
We can set tomorrow afternoon if that gives us a little bit more time.
Okay. Catherine Jarrell, come on up, please.
Catherine Jarrell.
Judge, I think Ms. Jarrell believes her bond may have already been posted. I don't know if pretrial can verify or. Oh.
She doesn't know her bond.
Okay.
I mean, I can ask. Hasn't been posted as of yet.
Hasn't been posted.
Okay, well, Ms. Jarrell, in the meantime, you've been charged with 6 counts. The first is possession of cocaine.
6.
Second is possession of drug paraphernalia. Third is driving while license suspended, second offense. Fourth is tag not assigned. Fifth is defective equipment. And sixth is failure to provide proof of insurance. If you find probable cause on all those, possession of cocaine will be a $1,000 bond. The possession of drug paraphernalia will be a $500 bond. Driving while license suspended will be a $500 bond. It'll be a 0 bond or ROR on the license not attached. And the other 2 are infractions that do not carry a bond. So the total bond is $2,000. Good luck to you, ma'am.
Judge, and speaking Ms. Jarrell, she believes her family have come up with everything that they've been able to, and she was hoping that the $1,000 would stay intact. As far as the other counts, Judge, I'd ask you to consider not disturbing what they're set out right now, as far as no bond necessary. She believes the only thing that her family will be able to come up with is just for count 1, the $1,000.
Just
Respectfully,
it's a residue.
I'm going to leave the $2,000 in place. Giselle Granville.
What do you say?
Giselle Granville. Good luck to you, ma'am.
Ms. Granville's here present at Maine.
Ms. Granville, you are charged with 1 count of arson in the first degree with people dwelling with people present. I do find probable cause.
Bring anybody with you.
I don't believe she has Broward priors. She's not on my list. I don't know if pretrial has any notes on her. Thank you.
Any recommendation?
Your Honor, I'm going to be asking for it's a first-degree felony. Even with no priors, I'm going to be asking for a $15,000 bond and no victim contact. Your Honor, I'm also going to be asking for a GPS monitor, and the reason being, I understand she has no priors. My concern is even more so for the victim's safety is her children's safety, namely where it mentions that one of the children has physical disabilities and requires a wheelchair to get out of the home.
Defense, any?
Judge, and speaking with Ms. Granville, as the state confirmed, she has no prior exposure to the criminal justice system. She's currently working. She works as a home health aide. She's been employed doing that for the past 5 months. She only makes $9 an hour. The only finances she only has $10 in the bank, owns no property. She lives in Coral Springs. She lives with her mother and her 8-year-old daughter. She believes that her mother is right now trying to gather the funds to help post it. We'd be asking you to consider a $5,000 bond on Ms. Granville's behalf.
After hearing the arguments, I will order a bond in the amount of $7,500 but with this condition of a GPS monitor. Yes. Yeah, no, she is allowed to work.
Thank you, Judge.
And Your Honor, we'd ask for no contact either with the named victim or her children.
That'll be granted. Alan Uribe, didn't we have Mr. Uribe this morning?
Yes.
He bonded anyway.
Who bonded? Who we are?
Alan Uribe.
Uribe.
Yeah, we had him this
Did
morning.
we do that?
He bonded, Hector.
Oh, he bonded? Okay.
Kevin Horner.
That'd be a medical reset, North Broward.
Okay. We'll reset him until tomorrow afternoon.
Yeah.
David Carmona Alvarez.
Mr. Alvarez is going to require a Spanish interpreter, Judge. Toma asiento, por favor.
Put him on recall. Myron Plummer.
Mr. Myron Plummer, come on up, please.
All right, Mr. Plummer, you are charged with one count of robbery with a firearm. If you find probable cause, you're currently being held no bond. You'll be held no bond until you see the division judge.
And Your Honor,
I'm sorry to interrupt, Mr. Lender.
Go ahead. No, go ahead.
Go ahead.
No, go ahead, Mr. Lender.
Just be asking for no contact. I understand he's being held no bond, but defendants have access to phones in the jail, and appears they know each other. So.
Okay, I'll order no victim contact.
Thank you.
Judge, the only thing I want to point out in the probable cause affidavit is I believe Mr. Plummer was arrested shortly thereafter, and no firearm was recovered off this person. The only this is basically a he said, she said. Hold on. The only thing that basically it seems to indicate is just the alleged victim indicating that this happened. No sort of physical or any other corroborating witnesses to support the victim's version of what happened. We'd ask you at this time, and I know it's a low standard, but we're asking you to reconsider finding probable cause for robbery of a firearm.
Your Honor, if I could make a brief record just in case the writ is filed, just in response to it. Your Honor, I would argue that it is not he said, she said, or he said. There is other evidence, physical evidence to support the allegations. One, to corroborate the victim's allegations that a shot was fired. The officer observed the area, the block, cement block above where the urgent care center was, and indicated it appeared a shot had been fired there. Additionally, the detective notes when taking a statement, when mentioning that they would be checking for gunpowder, Mr. Plummer responded by trying to clean his hands in the interrogation room.
I had read all that.
Oh, I know, I'm just making a record.
Based on the probable cause affidavit, I find probable cause, and I'm going to leave it at no bond at this point.
Thank you, Judge. And I explained to Mr. Plummer what would happen if he held no bond, that he did apply for a public defender. Public defender will come out and see him, and formally will move for an Arthur hearing. At this time, we are invoking Mr. Plummer's right to remain silent and not be questioned by law enforcement without his attorney present.
Okay, so noted. Thank you very much.
Thank you.
Sharing Henry.
Mr. Sharing Henry is here present. He declined to serve as public defender.
Okay, Mr. Henry. Six counts. First count is carrying a concealed firearm. Second count is use or display of a firearm during a felony. Three is removal of a serial number from a firearm. Fourth is possession with intent to deliver THC. 5 is possession of cannabis over 20 grams.
I thought I hired you.
6 is possession of drug paraphernalia. I do find probable cause on all of them. Carrying concealed firearm is going to be a $1,000 bond. Use or display, although I think it's there. I'm going to leave the bond at 0 at that point.
Well, it's
He's
at no
into-
bond right now, Judge.
That's a no bond?
No. I'm saying if leaving it as it is no bond. So if your intention was to ROR, you have to ROR.
It's going to be a 0, not a no bond.
Okay.
Okay, so
It's going to be an ROR. That's on count 2. Count 3 is $2,500 bond. Count 4 is $1,000 bond. Count 5 is a $1,000 bond. Count 6 is a $100 bond. That total is a $5,600 bond. I'm noting in the probable cause affidavit that apparently he was the driver of the vehicle, and unless I'm wrong, he was the driver of the vehicle, and the firearm was found in the passenger side door pocket, not within the defendant's reach.
Yes.
Although he did acknowledge ownership of the gun, I don't know that it was
Right.
in that vein of displaying it during a felony. Would like to say Carlos Robles.
Conti. Carlos. Conti. Carlos who?
Okay.
It's 11. Oh, Conti, Judge.
Yep. I got it. All right, Mr. Robles, you're charged with, is this an ad charge?
Now, it's a change of charge, Judge.
Okay.
Bond was originally set at $10,000.
Okay, sir, you're charged with burglary of an unoccupied dwelling. I find probable cause. Does he have priors?
Trespass and theft, 2010. Possession of cocaine, 01. One moment, Judge.
Had he bonded on that previous?
No, he's been in custody since his first appearance.
All right. Although it's not attached to my paperwork, I did read the probable cause affidavit. I do find probable cause. I'll set bond in the amount of $7,500.
They already had that charge, sir. Right, you lowered the bond.
Zoltan Szabo.
Conti.
Judge, he's been in custody since his first appearance. He filled out a public defender application, but he was found not indigent by the clerk. Will the court make an inquiry if he has a lawyer or not? Because I didn't see one on the clerk's website.
Okay, Mr. Szabo, do you have an attorney?
No, I don't have an attorney. I am indigent. I'm right now, as far as that goes.
I would just ask the court to provisionally appoint the public defender's office. He's been in custody since his arrest without the benefit of speaking with counsel.
All right, well, I will appoint the public defender
Thank
for
you.
purposes of this hearing, and I have read. That's fine. Yeah, that's fine. So you're charged with 2 different cases: robbery without a firearm. I do find probable cause on both those cases. It looks like they're 2 separate ones.
Yeah, they were both situations. He, let's see, one he went to a Walgreens.
Yeah.
Oh, did you? Okay, all right.
Although it's not here,
Okay, great. Yeah.
Any bond recommendations on them?
Your Honor, I would be asking for $10,000 per count.
Absolutely.
Mr. Zaspel, prior to your incarceration, where did you reside?
I lived in Hollywood. I worked in Hollywood as well.
Did you live in a house or apartment?
I lived in an apartment.
Okay. How long have you lived at that apartment?
At that apartment, I lived there for about 2 months.
Okay. Were you employed prior to your incarceration?
Yes, I was.
What
Yes.
did you do for work?
I'm a chef.
Okay. At what
A chef
restaurant?
at the Parrot Gourmet Coffee and Deli on 1917 Hollywood Boulevard, downtown Hollywood.
Sir, can you speak a little bit louder? I can't.
1917 Hollywood Boulevard, Parrot Coffee Gourmet Deli.
How long were you
downtown
employed
Hollywood.
there?
3 years.
Okay. How much can you afford in? How much can you afford in posting bond?
Right now, probably a couple $100. That's it.
Do you have family or friends here in the community that can help?
Not really. No.
Can you go back to that apartment?
No, not to that apartment. No. Possibly to my boss's house.
Can your boss bond you out?
Pardon me?
Can your boss post money for your bond?
He might be able to. If I could call him, yeah.
Can somebody turn the volume on the TV? I can barely hear. I don't know if the TV's on.
Volume. You can barely hear.
Yeah.
No, he's coming from here, but they're coming from there. Oh,
Huh?
there's a box on the ground here. Go ahead.
Sir, can you hear me?
Yeah, I can hear you.
Okay, that's much better. Okay, thank you.
Judge, he said most he can afford is $200 towards his bond. He seems to be. He does have a place to stay. I think he said he could stay with his employer. He lost his apartment while in custody. He does have a job he can go back to. He could possibly stay with his employer. He's a resident of Broward County for 20 years. I would ask the court to set a $2,500 bond on each count.
Respectfully, there are two separate incidents of robbery. If memory serves me, reading the probable cause affidavit, he concealed whether or not he had a gun and walked into a Walgreens and demanded cash. I'm setting bond in the amount of $10,000 on each case for a total of $20,000. If there's more evidence that needs to come out, I'm sure he can have it set in front of the division judge. Good luck to you, sir.
Thank you. Thank you.
Troy Craig.
Just have a seat. Chair Maine.
What is locked in there?
Yeah. Mr. Craig, you were charged this count with burglary of an unoccupied dwelling unarmed. Although
No, it was changed. He came through for occupied dwelling. It's been filed as guys. It's been filed as unoccupied. Bond was originally set at $7,500. I'm just checking to see if he had a VOP hold when he came through the first time. Just checking to see if that's still pending. Okay, Your Honor, he's got no bond holds on pending burglary, dwelling of voyeurism, and he's got a VOP hold on a resisting with violence bat Leo. I would just ask that, and $1,000 bond on a resisting with violence that was attached to this. I just ask that the original bond of $7,500 be kept in place, and he'll obviously have to see the judge on this case on his VOP.
yeah, respectfully, I'm setting bond at $25,000 on this case. The probable cause affidavit is not particularly flattering for Mr. Craig, and it looks like he was identified through DNA. So bond is set at $25,000. No return to the site, no victim contact.
Judge, and with Mr. Craig's finances, I know he's being held no bond on other accounts, but he has no sort of financial resources to post a $25,000 bond. Would you consider setting it to what it originally was?
No. In fact, I'm down from where I originally had noted on this. The facts of this case are not flattering, if not just a little bit creepy. So it's $25,000 bond. Jonathan Daniel.
Conti.
And this is also a change of charge on count 37. Originally, the count was occupied. It's been changed to unoccupied. Bond was originally set at $10,000.
All right, Mr. Daniel, you're charged, it's a change of charge, count number 37, it's a burglary of an unoccupied dwelling. Count 39 is a petty theft. I do find probable cause. I'll set bond on count 37 at $7,500. And I will leave count 39 as an ROR. Luck to you, sir.
Right.
Judge, we have William Brown here at the main jail on the second look docket.
I'm sorry?
Mr. Brown, come on. We have William Brown. He's on the second look docket. He's here at Maine.
We have a Spanish interpreter case.
Yeah, I know.
And we have a Spanish interpreter. Oh, you want to do the Spanish interpreter first?
Yeah,
we can do that.
First. Let me get
Okay. Have a seat, sir.
It's,
Mr. Carmona, Senor Carmona, come on up.
I do. Maria Salazar, certified court interpreter.
Okay, Mr. Carmona Alvarez, you were charged with 3 misdemeanor warrants.
Se le ha acusado de 3 delitos menores, de orden de arresto por 3 delitos menores.
It looks like all from the same case.
Todos son del mismo caso, aparentemente.
Bond on all 3 counts is $500 apiece.
Señor, en cada uno de estos casos va a ser $500.
I find probable cause to hold you on all the counts.
Y encuentro causa probable para retenerlo por cada uno de los 3
Can you
casos.
stop, can you stop doing that with your pen, please?
Oh, sorry.
You have, your total bond is $1,500.
La fianza total es $1,500.
And it looks like you have a status conference set on the 20th of this month at 10 a.m.
Y parece ser de que usted tiene una audiencia para ver el estatus de sus casos a las 10 de la mañana. Interpreter, I didn't hear the
10 o'clock in the morning.
At what
10 a.m.
At what date?
January 20th.
El día 20 de enero a las 10 de la mañana. Para ver el estatus de su caso.
Good luck to you, sir.
Que tenga buena
Thank you,
suerte.
Judge.
Thank you.
Hasta luego, muchas gracias.
Okay, so thank you very much. That's all.
You're welcome. That's it.
Mr. William Brown's here. Mr. Lender, the case number 17-170 MM10A. Judge, Mr. Brown's here on a petty theft. He has I believe it's $100 bond financially. He can't afford the bond, Judge. He's asking you to consider an ROR at this time. How long have you been in custody now?
Last Friday.
Since last Friday?
Yes.
Death priors?
Actually, from what I can tell, they're mostly drugs. The theft-related stuff, I mean, serious but dated. A couple robbery firearms, mid-'80s. A burglary in 1990. But other than that, as far as Broward goes, it's a lot of drug priors.
Does he have a place to stay?
He lives in Fort Lauderdale with his mother. He's 55 years old and been residing in our community for 27 years. He advised me he believes you're gonna be staying with your mom when you get out.
Yeah.
Yeah, wait to get relief. When you get relief, you call that. I don't know who's
Let me just, Your Honor, I'm gonna just check to make sure there's no restitution issues.
I have no probable cause.
Your Honor, I can proffer. Okay, they're handing one over. Yeah, it was at a Home Depot. Looks like any property was recovered. I have no objection if the court's inclined to resolve the matter. Offer from the state would be an adjudication, time served.
Judge, and Mr. Brown did indicate to me he wishes to accept the state's offer of time served.
Okay.
All right, he's gonna listen to the judge. Listen to the judge.
Mr. Brown,
Yes, sir.
did you hear what the state said? I was thinking the same thing as the state. But if you want to resolve your case today,
Yes, sir.
we would, I would adjudicate you guilty, give you credit for time you've already served. Is that something that you might want to do?
Yes, sir.
Okay, can you raise your right hand, please?
Yes, sir.
You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Can you state your name, please?
My name is William. My name is William Bernard Brown.
Okay, you put your hand down, sir. All right, Mr. Brown. How do you wish to plead to the charge of petty theft, guilty or no contest?
No contest, sir.
All right, I'll accept your no contest plea, and based on the representation from the state as well as a reading of the probable cause affidavit, I do find probable cause, and I'll accept your no contest plea, and I'll adjudicate you guilty of the charge of petty theft and sentence you to credit for time you already served. Okay?
Yes, sir.
Yeah, trying to put his hand.
I'll impose minimum court costs, and I'll give him 6 months to pay. Okay, thank you, sir. Good luck.
Judge Connor.
Judge, we're done here with me. Take
done?
care. Have a good. It's been a pleasure, Judge.
I have 2 at North Broward.
Okay.
Second look. Mr. Wintz, come on in. Michael Wintz, or Wiltz. Wiltz?
It's a 30-day motion.
Okay.
Just checking to see if it's been filed. Your Honor, it has been filed.
Okay, apparently Mr. Wiltz's case has been filed. So, it's a, Mr. Wiltz, you, I guess, have been formally charged with possession of cannabis 20 grams or less, and criminal attempt to solicit, which is a third-degree felony. I imagine you'll be set really quickly.
And just so you know, it's been charged as an attempted strong-arm robbery. We filed it yesterday. He should be getting his arraignment set any day.
Yeah, you'll get an arraignment date. Motion for ROR at this point is denied. Who else do you have at the...
I have Kaza. That's it. Shashad?
Kazi.
Kazi. Shashad Kazi.
How you doing, sir?
Good, how are you doing?
Judge, he's charged with the criminal mischief. I did speak with him last week. I could tell you he's a longtime resident of Broward County. He lives in Hollywood, Dania Beach, Florida. He was staying with his friend in a mobile home. We did sign an order, but for him to access his property for the purpose of posting bond, it was a $25 bond. That's not a bond he can afford. I would ask the court if they could verify an address, can you place him on pretrial release pending?
Please give me one ROR, sir, because my father is in the hospital, sir.
This, Your Honor, you have the report? Because it's a criminal mischief, but it's a little bit more than that.
Yeah, unfortunately, Mr. Kazi, if it was just a run-of-the-mill criminal mischief, I'd be more than happy to resolve your case today. But there's allegations of a knife being brandished and damage done to a car that I'm not even sure what it's...
Somebody robbed me, sir. I was trying to save myself and I hit my head.
Don't talk about what happened.
So respectfully,
I'm sorry.
I'm not going to resolve this case. It'll be set in division. I think the victim has a right to be heard on that case. Thank you.
Court transfer this matter to Judge Lerner Wren.
Is there an indication that
I'm not saying he's incompetent. I'm just saying she could work on getting him some type of services.
fair enough? I'll
And,
transfer him.
and no objection from the state.
If they feel that he's not qualified for that division, they can transfer him back.
Yep.
Good luck to you, sir.
Conti, Your Honor.
Yes.
We got Rodney Smith. Happy New Year, Your Honor.
That's a 30 day and.
I didn't hear what he said. Sorry about me. Can
No,
you please?
Your Honor, we've not yet filed an information. Mr. Smith is entitled to an ROR at this time.
Okay, Mr. Smith, it is indeed a happy new year for you. The state has not filed the charges within the allotted time frame, so I'm going to release you ROR at this time, okay?
Mary, thank you, sir.
We got Patrick
Dusnor.
This is another 30 day. We have not filed an information. Mr. Dusenord is entitled to an ROR at this time.
Mr. Dusenor, how are you doing?
I'm doing all right, and you?
Okay, I think you're doing a little bit better. The state has not filed charges within 30 days, so you're entitled to a release on your own recognizance, and that's what I'm doing.
Thank you, sir.
Good luck to you, sir.
Thank you.
Step up. Step up. Tell me your name.
Can I say something?
Melvin Hamberry.
Okay.
Hamberry.
All right. Sir, what's your name?
Melvin Hamberry.
I don't even have it.
Okay, Mr. Hamberry, you have been charged with battery. Thank you. Being handled probable cause. Okay, Mr. Hamberry, you're charged with battery. After reading the probable cause affidavit, I think it's best that we set this case in division. I think the victim has the right to be heard on this matter, so good luck to you.
I'll tell you. Stand up here. We got Alan McKenzie.
Yes, good morning. Good evening, Judge.
Walk behind him and have a seat.
All right, Mr. McKenzie, you're charged with trespass.
Yes, sir.
And it appears from the probable cause affidavit that that there was a trespass warning, and at least as far as they're concerned, you keep coming back to the supermarket on University Drive. State?
One moment. He just pled out a trespass. This was at 3108 South University Drive. He pled out a trespass in December at 3122 South University Drive.
Was same location, Judge?
No, it's not the same location.
It's in the same area.
The same shopping
Same
center.
Shopping center.
Okay.
I guess my initial thought upon reading the first PC, the interaction with the employee, I don't know maybe if he was amenable, if Judge Lerner Wren could assist. That's just my thought. Rather than just sending him back out where he's likely to go right back to the shopping center again.
Judge, I didn't have an opportunity to speak with him. Sir, Sir, if the judge were to resolve your case today, do you have a place to go?
I don't have a place to go, sir.
He said he doesn't have a place to go.
No. I've been here. Have some family down there. I've been here from day to day, and I don't see them turn up. And there was an Asian selling English. An Asian selling English. I will order something and he give me wrong things, and I talk to him about it. Not the person do it, sir. An Asian handling president the business and handling in English, and he give me the thing them wrong. I tell him no, you give me them wrong. So it was no big dispute, Your Honor. Oh, why that?
Judge, Judge, will the court, unless there are failures to appear, will the court ROR him? He's been in custody for a few days now. Allow him to return to court. Seems like he has a
I
reasonable.
don't know how that would happen. I mean, he doesn't have.
He could go, there's a public library. He could go access the computer, check, there's clerk course.
That's fantastic if that would happen. If he wants to, Mr. McKenzie, if you want to resolve your case today, I'd sentence you to 10 days in the jail, credit for the 6 days you've already served. It's up to you if you want to resolve that. Otherwise, I'll set it in division, in Judge Lerner Wren's division.
Secondly? So is it?
Judge, for the matter to go to Judge Lerner Wren, it would possibly be on our docket sometime this week. You can get him.
I'm not sure that he understands what I'm saying to him. So I'm going to go ahead and transfer this into Judge Lerner Wren's division. And let
What did you say to me then? But I don't mean no aggress against them, officer. Your Honor.
He's gonna send you to Judge Lerner Wren. He's gonna see one more different judge.
Okay, and she'll
We're
get
gonna see a
on
different
the
judge.
docket pretty quickly. She's pretty good about that. All right, good luck to you, sir.
All right, tell him your name. Your Honor.
I'm sorry?
Christopher Ramasar. Good afternoon.
How are you doing?
Good.
Yeah. No, I'm transferring Mr. McKenzie to Lerner Wren, yes. On Mr. Ramasar.
That's correct.
Do we have, is there a proper cause?
What's your call, right? What's your extension? Call you back.
Yeah.
Your extension. Let me check this out and I'll call you right back, okay?
Oh, thank you very much.
Yeah, I remember Mr. Ramasar. The issue was his prior record, Your Honor. 2015, grand theft between $10,000 and $20,000, resisting without violence. 2014, grand theft auto with a violation of probation and battery. 2014, unlawful use of false name ID. 2013, grand theft with a VOP. 2012, resisting without violence, failure to comply with lawful order.
Those charges drop. His ties.
Sorry?
May I inquire as to his ties?
Absolutely.
Sir, do you have a place prior to your incarceration? Did you have a place where did you reside prior to your incarceration?
I have a residence in Davie.
Is that a house or apartment?
It's an apartment.
How long have you lived there?
It's over 10 years. I've been a resident of Broward County for 20.
Okay. How much can you afford in bond?
At this moment, I have no means of bonds, Your Honor. I have nobody to bond me out. My mother is taking care of my 11-year-old daughter and my 7-year-old son, so she's not able to bond me out.
Judge, will the court consider placing him on pretrial?
Bond is $100.
It's not a bond he can afford.
I mean,
you would already bonded out.
I'm not likely to. But if he wants to resolve the case today, I would adjudicate him, give him 20 days in the Broward County Jail with credit for the time he served.
Yes, Your Honor.
All right, Mr. Ramsar, can you raise your right hand? Swear or affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your name, please?
My name is Christopher Ramasar.
Mr. Ramasar, you put your hand down. Mr. Ramasar, you indicated to me that you wanted to accept the court's offer of an adjudication, 20 days Broward County Jail with credit for 7 days time served. Is that something you want
Yes.
to do? How do you wish to plead?
Yes, Your Honor.
Guilty or no contest?
No contest, Your Honor.
Okay, I'll accept your no contest plea, and I will sentence you to an adjudication, 20 days Broward County Jail, credit for time served.
All right, thank you, Your Honor.
And the last one, Your Honor, is Mr. Falk.
Timothy Falk?
Yes, sir.
How you doing?
I'm alright, sir. How about yourself?
If I could trouble you for one more probable cause affidavit.
All right, hold on. Let's let out the magistrate's area.
Judge
Okay,
Lerner,
that's cool.
so Judge Lerner Rum did it on.
Hold on, we're just gonna check into it. Yeah, hold on.
Yeah, if it has to
Judge provide those.
Okay, but it's let out the felony.
What do you want from me?
Yeah.
Tell him to pull up the findings.
Calls and stuff?
One moment, Judge. I don't see any Broward priors.
Deputy.
And it looks like they stopped him outside the store, so I imagine they recovered the property. Yeah. I have no objection if the court's inclined to resolve it. I have no objection if you're inclined to make an offer.
Judge, will the court consider time served in light of the fact that the property was recovered?
Mr. Falk,
Yes, sir.
I note that you're from Macon? You're from Macon?
Yes, sir.
Okay.
Yes, sir.
Isn't that where the Seven Bridges Road is?
Yes, sir.
Great song. All right, if you
Yes,
want to resolve your case today, I understand that it looks like from the probable cause affidavit that Lowe's got all their property back. I would adjudicate you guilty, give you credit for the time you've already served, if that's something that you want to do today. Which means basically means adjudicate time served. You would be out today.
Oh, yes, sir.
Okay. Can you raise your right hand, Mr. Falk?
Yes,
Swear or
sir.
affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Can you state your name, please? You put your hand down.
Let me talk to you.
Timothy Shane Falk.
Okay. Mr. Falk, you indicated to me that you wanted to accept the plea of adjudication credit for time served. Is that correct?
And under the
Yes, sir.
How do you wish to
where
plead?
it
Guilty or
says
no contest?
hearing held, magistrate
No
finds there
contest?
probable cause
Okay, I'll
found.
accept your no contest plea on the charge of petty theft, and I will
Yes.
adjudicate you
If
guilty,
you
give you
click on
credit
that,
for the
you will
7 days
see-
you already served. Good luck to you.
And,
Thank you, Your Honor,
sir, I
so
have
very
to
much.
caution you that if you have any future thefts, this is being your first one. If you're arrested or charged with 2 other thefts, the state can file it as a felony.
That's right, sir. Do you understand what he's saying?
Sir,
He's
I'm
saying,
finna go in the Lamb of God halfway house. I ain't with it
All
no
right.
more.
well, that's fine, sir, but all that being what it is, if you get
Yes, sir,
caught
I
again,
understand.
if you get caught again, these cases end up being
judge
worse and
ruled.
worse, and
Yes, sir.
petty thefts become grand thefts after a certain period of time. So you understand that by being adjudicated on this, if you get into trouble again, it's going to be potentially a higher degree. You understand that?
Yes, sir.
Okay.
Looks like it.
All right. Good luck to you, sir.
Thank you, Your Honor. You have a good day.
You too.
I'm sending it to her right now.
Thank you. That's it, Your Honor.
Okay. Anybody else have anything else?
Who's asking about this?
You should have Mariah Lee.
Any attorney or any ASA is asking.
I sent it to her.
But I didn't hear anything. I didn't hear.
Yeah. Do we have
Then show it.
Mariah Lee?
All right, sir.
She got it? I understood her.
It's an ROR, Judge.
Okay. Miss Lee, you were charged with a criminal mischief to a public phone. I didn't even know we had any of those anymore. That being said, the state has indicated to me that the charges have not been filed as of this point, so you're entitled to a release on your own recognizance. I'm going to order your release on your own recognizance. Good luck to you, ma'am. Basically, it means that you're done for today. Okay?
All right. That's it?
I think she thinks you're like pranking her or something. She's like, look at her.
About that orange ball.